Good morning, and may it please the court. My name is Natalie Atkinson. I represent the appellant and plaintiff below, Dominique Spatafor, in this matter. By granting summary judgment in favor of the city of Clarksburg, the district court improperly weighed evidence, gave the city the benefit of every reasonable inference, and usurped the role of the jury. The district court's order on Ms. Spatafor's claims for FMLA retaliation and her West Virginia state law claim for disability discrimination must be reversed for three independent reasons. First, the district court substituted its judgment for that of the jury by deciding genuine disputed issues of material fact. That's not its role on summary judgment. Second, the district court did not consider Ms. Spatafor's evidence of pretext. Third, the district court did not consider discrimination as a motivating factor contributing to Ms. Spatafor's discharge. And these are all true as to Ms. Spatafor's FMLA claim, as well as to her West Virginia Human Rights Act disability claim. To briefly address some of the facts, beginning in 2014, Ms. Spatafor was employed by the city of Clarksburg, West Virginia as a marketing specialist. From 2014 to 2021, she had no disciplinary issues. There's no write-ups in her reports. She was never suspended. She was never placed on an improvement plan. Ms. Spatafor suffers from anorexia and Crohn's disease. In mid-2021, she requested the opportunity to take FMLA leave so that she could seek inpatient residential treatment for her eating disorder. She returned from FMLA leave on September 13th of 2021. Within days of her returning, she's placed on a PIP, or an improvement plan, for the first time in her tenure with the city of Clarksburg. And she testified that she's told that if she doesn't meet heightened requirements for her job, she's going to be terminated. She then agrees after discussion with her employer to take a different job, a job that was below her qualifications at the time as an accounting specialist with the city, which she agreed to do. And then about 3 months later, and while she's out sick with COVID-19, she's terminated.
But in between that, right, there's the social media activity in mid-December?
Right, Your Honor.
Okay, so, I mean, I feel like that's kind of an important piece of the story.
It is, and of course, that's what the city will point to and has pointed to as the reason for her termination.
And why is that not the most reasonable inference, that the reason she was terminated were the undisputed violations of workplace policy days before the termination and not something that happened, months earlier?
Sure, a few responses to that, Judge Harris. The city relied on three things that it stated were allegedly the reason for Ms. Spatafor's termination. The first was her failure to follow the city's grievance policy. Ms. Spatafor, as I mentioned, was out sick on COVID-19. And
that was the grievance. Sorry, I'm just making sure. I want to understand all three things. I just want to make sure I understand. Was the grievance policy about the social media? Was the alleged failure to follow the grievance policy, was that about the social media issue? As
I understand it, Your Honor, it was about Ms. Spatafor's complaints for not being paid while her employer required her to be out while she was sick with COVID-19.
It's about the email with the COVID grievance to the city council? Okay.
Right. So Ms. Spatafor gets sick, end of 2021.
But it's not, I just want,
about the Facebook.
Judge Harris's comment to be about the social media, and that's really that's different from the grievance.
Correct.
Okay, I thought that was right, but I thought in response to her question about social media, you talked about grievance, and so I just wasn't following.
Correct, and hopefully I can tie these things together, but two different things. So the city says that we're firing you because you posted on Facebook, you put an internal memorandum on Facebook, and because you didn't follow the grievance policy. The grievance policy, her alleged failure to follow the grievance policy was not related to the Facebook communication. So first, if we take the grievance issue, she was personal friends with the city of Clarksburg's, the mayor of the city's wife at the time.
Oh, I was wondering about that. They were friends?
Right, they had a personal relationship. So she reaches out to the mayor's wife, who she knows personally, to complain about the city requiring her to be off work because she has COVID-19, but not paying her for it.
Can I just ask, because I had the same response that Judge Harris had, where would I look in the record to see that they had a personal relationship?
The plaintiff's deposition testimony.
Okay.
that was discussed there.
Because that seemed to be ambiguous to me, but maybe I'll go back and look at that. Because it doesn't seem to match up, the mayor's wife doesn't seem to suggest that there was a personal relationship.
Right, well,
In
and,
context of what's going on. And I understand we're giving your client the inference, but it's one thing to know them, it's another thing you represent, like, that there's a personal relationship, they're friends or something.
I believe the deposition speaks to that, Your Honor. I don't know if they were close friends, and I don't think they socialized on the weekends necessarily, but at the time, and the record would reflect, the plaintiff, Ms. Spatafor, was having difficulty with her supervisor, the city's manager, who would have been the person that she was grieving to under the policy. And because of those personal conflicts, opted to reach out to the city mayor's wife, excuse me.
But there's no dispute that that was a violation of the grievance policy, right?
That was not proper procedure under the grievance policy. We acknowledge that. So that happens in December for the second time. She had also reached out to the mayor's wife in October, again expressing concerns about her employment. The city does.
Same time telling the wife, how about get your husband to do something about this?
Right. The city.
Which is no longer like talking to a friend, it's making a request that the mayor intervene in her employment relationship.
Right, and she's asking for the mayor to be alerted to these issues and wants to draw attention to her dissatisfaction with what's going on at work. When that happens in October, the city takes no action at all about it. The city mayor forwards the email from Ms. Spatafor to the city manager. She doesn't get a warning about it, she doesn't get a write-up.
So I actually, well, it doesn't matter, we're not a jury, but I actually thought that could cut both ways, right? It's kind of, in its own way, a bit of a good fact for the city that they weren't sort of poised to try to come after her as soon as they could after she took leave.
Yeah, and I think it's, again, an inference that could possibly go both ways. When we're at the summary judgment stage, the plaintiff gets the benefits of those inferences. The city took no action, though, and that's a fact that's, I think, undisputed in the record. And then in December, when she does it again, all of a sudden it's grounds not for discipline under the tiered policy that the city endorses, but termination outright, without so much of a conversation with Ms. Spatafor. And then when it comes to the Facebook communication, which was the other reason that the city relied on for her termination. Ms. Spatafor is out sick with COVID. So the factual background here, the West Virginia governor said all state employees get Christmas Eve off of work, and they also get Christmas off of work. There's a... Just
so I'm clear, is your argument that she was permitted to do this, or is this like justification for violating the policy? I mean, are we trying to evaluate whether, same thing I was trying to ask with the grievance, right? We all agree that she didn't follow the grievance policy. You have some reasons why that was done. Are we doing the same thing here on Facebook? She wasn't permitted to do this under the employee manual, but your point here is they're extenuating circumstances.
Right, and that these are weak or false reasons for jumping to a termination for someone who has never had a problem at work. You know, again, this is all happening while Ms. Spatafor is out sick with COVID. There's no discussion with her. There's no saying, hey, you don't cut it out posting on social media. We're going to suspend you. Nothing like that. She's immediately let go. And when you take the fact that the dissatisfaction with Ms. Spatafor's work starts immediately when she comes back from taking time off for personal illness, and that this escalates, and that again, when she's off work for personal illness, her employer decides to terminate her, again, without taking any less drastic or intervening steps. Our argument before the district court was that a reasonable inference there, particularly with the direct evidence that they discussed her FMLA leave at the time that they were deciding to terminate her, that this creates a reasonable inference under the burden shifting framework.
Can I just ask you a question about the framework? You do argue before the district court, and I think here, that we should be applying motivating factor causation. But what I didn't see either in the district court papers or in the brief before us is sort of an argument under that standard. When it comes time to make your argument, you're arguing just straight out, it's a jury question, the reasons given were false, the real reason was retaliation. have you developed an argument that even if that is not true, there's another way of looking at the evidence that would match up with motivating factor causation?
Yeah, I mean, I think certainly, Your Honor, when we're developing this evidence in front of the district court, I think it's, and thinking about presenting it to the jury, our preference and the way we would rather present the arguments to the jury is that the plaintiff was terminated for illegitimate reasons. But in our briefing before the district court, we also asked, in the alternative, Judge, you could reasonably find that Ms. Spatafor's exercise of her right to take FMLA leave was a motivating factor in the decision to terminate her. And the district court just didn't address that at all.
Can I follow up on that question?
Please.
You sort of cite to the regulation, which is, and the cases that adopt this regulation, all of that obviously is like pre-Loper Bright. And so I'm a little troubled with what we're supposed to do here. We have a case called Fry from 2020 that addresses this a little bit because we have an earlier case, Yashinko, that says this type of retaliation action falls under A2. The regulation only applies to A1. Maybe there's like a Brand X problem, pre-Loper Bright, but we don't have a Brand X problem. So it seems like Yashinko tells us we're under A2. The regulation doesn't apply to A2. The motivating factor regulation doesn't apply under A2. And you don't develop any argument for why, separate from the regulation, we ought to adopt a motivating factor type of analysis, given the sort of language that, the by reason of language that cases like Gross and others have required but for a cause.
On A2.
So can you help me sort of like tease through, I know I just gave you a lot, and nobody cites to Fry, which seems to sort of lay out this rub. Can you help me understand what I'm supposed to do with that, and what, have you made an argument outside of the like Loper Bright world that allows us to do what you want us to do?
Yeah, well, let me turn to Fry now because I think it gives you that guideline. Where Fry says, Yashenko says that the FMLA retaliation analysis goes under A2, but you have subsequent federal, administrative regulations that say it falls under A1. And if that's the case, I think the court can reasonably hold differently than Yashenko did and say these.
On what theory is that? Like, what case would you give me that we can ignore a prior panel precedent? You would have given me, a year ago, you'd have given me Brand X.
Right.
But you can't give me Brand X now,
Yeah.
right, post Loper Bright.
Yeah, I would give you Brand X.
But you recognize you can't do that, right? Loper Bright tells you can't do Brand X. That's what Fry said. I don't know what we're going to do here. Brand X seems like a really difficult question, but it's not a question after Loper,
Yeah.
right? So I think this is the rub that I'm trying to understand. It seems like to me we're bound by Yashenko, at least this panel is. And that sort of puts us in a bucket that I have no argument for you for why this motivating factor analysis applies.
Right.
I don't actually have no idea whether you're right about that as a first principles matter, but the argument you've made seems to be plainly foreclosed in this court.
Right. Well, and then the court becomes in the position where the second, third, fifth, seventh, eighth circuits have all said FMLA retaliation falls under A1. Then perhaps the question is, then does the court take it up on
There are
bonk?
two different things that you can do there, right? One is you can go to 1 First Street, or 2, you can file for en banc review. But
Right.
and pre-Loper Bright, you could compound on Brand X, but it seems like we're sort of stuck there, right?
Right, and what I would ask is for the court to look at Fry's analysis, look at Yashenko, because I think it's fairly clear with the administrative guidance that's come out from Yashenko forward, that A1 is the correct subpart for this type of claim in which motivating factor applies.
Of cases, Hannah P. and otherwise, that adopt this Yashenko divide, that A1 is fundamentally different from these retaliation cases, which are A2. And I'll just say, it is not obvious to me from a first principles matter that A1 is actually what you want. maybe you do, I don't actually know. But the point being is that that would require us to like reframe the way we manage FMLA cases, despite a bunch of binding panel precedent.
Right, it would require substantive and significant change. I mean, if I could say one more thing, Your Honor.
Please,
It's
please.
just,
I'm totally interested in this, and with Judge Gregory's permission, if you've got more to help me understand what to do with this, I'm open to it.
yeah, no, Judge Richardson, you don't need me to draw your attention to the statutory language, I suppose, but.
Counsel,
I'm sorry,
I have a question for you.
please.
Even if you did, as Judge Richardson and Judge Harris talked about, the motivating factor, what tribal issue of fact have you developed? I think that's Judge Harris, the essence. What is the tribal issue of fact that it was a retaliatory motive that you've developed? You can't just say, well, she took FMLA and then shortly thereafter, but what tribal fact do you have in that regard? You've developed in this record at this point,
Right.
that you can go further.
So first, Your Honor, I draw your attention to the admissions that the city discussed the plaintiff's taking of FMLA leave when they decided to fire her.
That's a question
So-
about the council having some
Yeah,
questions
wasn't
there.
that
You
just
can't.
the guy saying, like, I don't want to do anything that violates the FMLA, and counsel saying, well, the reasons you have given have nothing to do with the leave, so you're not exposed. I don't see how that counts against the city.
Well, again, from our perspective, I mean, there's two different inferences that can be drawn from the fact that they're discussing that
But
information.
you need
But-
some tribal issues of fact, though. You know, inference upon inference upon inference is very difficult in terms of you've established a tribal issue of fact. I mean, basically, you would say, well, took the leave, shortly thereafter, she was fired. What's the tribal fact as to connect that to be retaliatory?
Right, this,
I mean, did someone say something like, look, you take one more leave, you're out of here, or I don't like this, you're bothering our operations, I wish I had a healthier person. Those are the kind of things normally, I'm just an example, it doesn't have to be that, but I'm just asking you, what is it?
right. What we would point to and what the plaintiff would testify to is that she's had 6 to 7 years of experience with this employer without a problem. And within 3 weeks of her returning, her employer sits her down and says, we're going to fire you if you don't.
I mean, the whole point of your grievance argument, right, is that she had such conflict with her supervisor that she couldn't talk to them, right?
But it all starts
And then at
after.
the same time, you want us to believe that, like, she was in a great spot with her supervisor, right? Like, those two can't be, I mean, what am I doing with
No,
that?
you're exactly right, but the timing, it doesn't start until after she comes back from FMLA leave, when her supervisor sits her down and says, I expect more from you, here's my expectations, comply with them or you're out.
But didn't he actually share some of his time with her?
He did.
It doesn't seem like very retaliatory, mean-spirited, does it?
He did. I mean, that would be evidence that would be presented at trial.
Exactly. I mean, but other things that talk about, communications and timing and things like that, and she was placed on a PIP, things like that, it looked like they went to job-related areas. I mean, what? So in other words, you would say that every case would go forward just by saying, took the leave, shortly thereafter, she had a PIP and those problems, therefore that goes to a trial, no summary judgment. Right? That's what you're telling us?
I think with the temporal proximity between the time she returns from leave and when she's placed on a PIP, the fact that she doesn't have any problems earlier, and then the escalation of these issues and the firing when, again, she's out sick, Your Honor, is what we would rely on.
Why does it matter that she was out sick? Just because that seems mean?
Well, because our position would be that the challenges with her employer start when she is no longer able or available to be at work due to her health issues.
I'm sorry, when she's back in August and September, or I thought you were saying it's because she got fired when she was out with COVID?
She took FMLA leave, correct, in August and September.
So why does it matter that when she was fired, she was out because she was sick with COVID?
I think what we would argue to the jury is that it matters because this is another example of her not being at work
Oh, okay.
because
I
she
didn't get that. Okay.
is sick or unable to work due to a health condition.
Oh, you're saying she
Now,
was-
go ahead, I think, something else you wanted to say?
No, I got it.
You good, Judge?
I'm good, thank you.
Judge Harris?
Okay.
Thank you.
Counsel- Thank you, counsel. Ms. Durst?
Good morning. May it please the court. My name's Tiffany Durst, and I represent the appellee, the defendant below, in the case, the city of Clarksburg. I did want to start off by saying that we believe that the Yashchenko analysis should apply to the facts of this case. And applying that analysis, we do not believe that the plaintiff, as Judge Gregory articulated, has presented a triable issue of fact.
Can you just answer one question for me? As we stand here today, why did the city fire Ms. Spatafor? Because I counted 3 different reasons given in your brief.
The city fired Ms. Spatafor because she violated the grievance policy.
So, I'm sorry, so that is the email to the city council?
It is, Your Honor.
Okay.
Because she, the process at the time.
No, I got that. So what else? The email to the city council?
The Facebook messages.
And is that the parts where she posts the memo?
And that she made disparaging comments about the city manager on those posts.
Okay.
When you read the post.
So the 2 posts that include the memo, okay?
Yes, and that she had reached out to the mayor's wife.
Okay, so sometimes when you say why she was fired, you mention the reaching out to the mayor's wife. Sometimes you don't. Sometimes you mention that the Facebook postings had false statements. Sometimes you don't. I actually have never seen a case where even by the time of the appellate brief, the defendant still can't say consistently why someone was fired.
Well, I think the city has been consistent in that it was with regard to the
Literally,
posting.
your brief is inconsistent. On different pages, it says different things.
She was fired, Judge Harris, because she made posts on Facebook.
Okay, so the post. Okay.
Yes, and the internal memo.
Did it matter that they were false? Or was it just that they had an internal document?
I think it was both.
You think?
Yes, when you look at the evidence that was developed below, particularly the deposition testimony of the city attorney, there was a discussion with regard to the comments that were posted. One of the falsities was that she had posted regarding the employees not being given Christmas Eve off, which was false. What factually happened was.
No, I know it happened. So on page 27 of your brief, you say the city has consistently stated that the plaintiff was terminated for 2 reasons: violating the city's grievance policy by contacting the city council, and then posting an internal city memorandum to Facebook on 2 occasions. Nothing about the mayor's wife. But then on page 38, all of a sudden, it's actually because of the mayor's wife. And I guess, and then back on 41, we go back to, no, it's only the 2 things. And I guess, I mean, shifting rationales are, we have said many times, are evidence of pretext. And again, usually, like, you see the shifting rationales in discovery, but by the time you get to a litigating position, everyone's clear on what happened. Or, I'm sorry, the defendant is clear on what happened. And it is just hard for me to understand why, if you can't nail this down even in your brief, that doesn't raise questions.
I don't think there's a question of fact with regard to pretext when you look at the evidence that was developed. She posted on Facebook an internal memo, was not supposed, and it doesn't matter whether below they argued, well, it didn't create harm to the city by posting the internal memo. The fact that it didn't create harm doesn't eliminate the fact that the plaintiff violated policy by posting an internal memo. Plaintiff initially had also argued by posting that memo that she was engaging in protected speech. the district court found that she did not engage in protected speech, and she did not raise that issue on appeal before this honorable court. So the fact is, she posted an internal memo that was not protected speech, and she bypassed the grievance policy by going
Can I ask
to...
about the grievance policy? Because
Yes, Judge
I think
Richardson.
maybe I understood it differently, and so I'm curious. So I understood the grievance, and I do think your brief, like, sometimes conflates these two ideas, but the actual evidence that was before the district court, as opposed to the arguments here, is that the grievance violation includes both the council letter and the mayor's wife. Like, both of those fall into this bucket of the grievance problem, right? And then that's separate from what I'll call the social media problem. And the social media problem includes several aspects about it that are all there. And that when we look at the sort of actual evidence, that those are the two buckets. I think you would sometimes say it's three things. I've never understood it as three things. I understand it as two things from the actual record. But what I take in part Judge Harris's question to be like, what do I do about the fact that the evidence looks that way, but your brief at various times says two things, sometimes it says three things, and when it's describing the things, it describes them in like quite different ways.
I think that the evidence developed below those substantiates the fact that she was terminated for violating the grievance policy, as you said, one bucket, and that includes the email to the city council and included others on that, and reaching out to the mayor's wife in December and asking her directly to reach out to the mayor. So that's the one bucket. That is the evidence for violating the grievance policy. The other bucket of evidence is the violation of the social media policy by posting things on Facebook.
And so where would so if I wanted to find in the record, am I looking at the letter that was written? I know Falk didn't write the letter. I've forgotten the name of it.
Richard Marsh, Your Honor.
Marsh,
Yes.
thank you. Am I looking at the Marsh letter? Like, where am I looking if what I'm trying to say is, what is the reason that was given? And is that reason sort of maintained and consistent?
I think if you look at Richard Marsh's deposition, Your Honor, because Mr. Marsh was deposed, in this case, the city asserted advice of counsel and produced that communication, and Attorney Marsh was deposed. And in his deposition testimony, I believe he addressed the reasoning behind her termination, because it was also at that part where there was questions about, well, you also discussed her FMLA during this time. So there was a discussion between and amongst the city manager and the city attorney, and then the city attorney took the information from that discussion and prepared the termination letter to Ms. Spatafor.
But the termination letter doesn't say anything about the grievance policy.
It uses insolence, insubordination.
Insolence. Do you guys use insolence for violation of workplace policy? I mean, insolence sort of jumped out at me.
The city attorney chose to use that phrase, Your Honor, and provided a definition of what he was meaning by the term insolence in the letter. It was rude, disrespectful behavior by the posting of the things on the social media site, making comments, disparaging comments about the city manager.
So where do I see where do I find the grievance, what I'm calling the grievance bucket, right? The failure to comply with the grievance procedure. Where do I see that in the factual record?
The factual record included the employee handbook, which outlines the grievance policy.
No, I don't have any doubt about what the grievance problem was. Where do I see that was the reason, or a reason, I should say, that she was fired?
I think in Attorney Marsh's deposition, Your Honor.
And your point is like, Marsh wrote a letter to show off his vocabulary skills, but the deposition is where we sort of see what the reasons were.
Yes.
And I take your point of Falk's, small vocabulary is not a relevant piece of the question.
No, the fact that he didn't know what the term insolence meant, he knew what the...
I'm not totally sure I know what it means, if I'm honest about it. I mean, I have a sense of what it means, but It seemed like an odd word in this context.
I would candidly agree with that statement, Judge Richardson. But I think when you look at the facts supporting the basis for the letter, and what we have to go back and look at is, and I think it goes to the question that Judge Gregory asked, is that Ms. Spatafor requested and was granted FMLA leave in the summer of 2021. And under the employee handbook, she was entitled, well, she was not entitled, she could request donated leave. That was subject to the approval of the city manager. So the city manager, the same individual who ultimately terminated Ms. Spatafor, gave her permission to seek leave from other employees so she would not have to be off paid leave potentially. So he granted her request to seek donated leave. He even donated leave to her. The entire time that she was off on the FMLA leave, she was paid for her time because she had been given enough donated leave. When she returned, what happens under the handbook is if you're donated more leave than you need, the donated leave is returned to those who donated it on like a pro rata basis. So the reason that I point this out is that ties into some of her complaints in December when she was off on COVID. She, in the email to the city council and others, said that the leave was taken from her, implying that it was somehow improper to take donated leave from her, and it was not. It was in compliance with the handbook provision.
As if it vested in her.
Exactly,
Right.
Judge Gregory. And so there's that information. The other point with regard to the FMLA leave is when she returned in September, she asked to take additional, like longer lunch breaks and work later so she could do some online counseling with regard to the treatment that she had received for the eating disorder. The city accommodated that. There was no issue with her doing that. September 20th rolls around and she's asked, as the marketing and community relations specialist, she's asked to make a post on Facebook. And I think it's important that this is an individual who had served in this role and then in December makes posts on social media. She was the marketing and community relations specialist for an extended period of time and was asked to make a post. It was not done so. The city
So
manager...
What about this? I take one of your colleagues' argument, or sort of maybe implicit in your colleague's argument, is Falk, and when Falk is in his deposition, that seems to be the first time that we hear about the social media policy. What do I do with that? I mean, I understand that, throughout there's been discussion about she was fired because of the Facebook post, right? The conduct is the same, but we don't really hear about the policy until like Falk's deposition. At least that's what I gather was the first time we hear about the policy. Does it matter that the connecting the conduct to the policy we don't sort of see until later?
I don't believe so, because the social media policy was articulated in the handbook, and Ms. Spatafor received the handbook, and she acknowledged that in her deposition that the policy, and the policy was that if you were identifying, if your page identified you as an employee of the city of Clarksburg, for instance, you could still make posts, but you had to make some kind of disclaimer that you were not making it, as an employee of the city. So it wasn't that she was prohibited necessarily from making posts herself. So she was familiar with the social media policy, and that testimony was elicited from her during her deposition as well. So she was aware of the policy. The handbook was there. She acknowledged receipt of the handbook. So I think there is evidence in the record that Ms. Spatafor was aware, by having received the social media policy that was in the handbook, that she was not supposed to do what she did. And I don't think that there's any, at least, dispute from the briefs at the district court level in here and in the argument this morning that she wasn't supposed to have done what she did. I mean...
There's no evidence that the policy was ad hoc in this case?
No. It was a written policy that was applied, to everybody across the board.
Do you, don't feel the need to, but I feel like I should give you the opportunity since I gave your colleague the chance. This Fry-Yashinko line, you began by saying you agree Yashinko controls, and as does Fry, and we're sort of stuck with those under A2, and so we're not doing the sort of regulation motivating factor analysis that your colleague is suggesting.
I agree with that, Your Honor. I think that for the case that's pending before this court, I think the Yashinko analysis is what this court should apply in determining whether the district court, usurped the province of the jury. We would submit that it did not, that there are no triable issues of fact with regard.
I'm
Yeah,
sorry, just.
that's
just
okay, Judge
before we-
Harris.
I just wanted, one issue that your colleague has raised is the departure from the progressive discipline policy that it seems like both the city manager and the city attorney did say in their depositions that generally there's this progressive policy. And it was sort of striking to me, sort of how this thing moved with lightning speed. I mean, it was like the exact opposite of progressive discipline. She gets terminated for things that happen on December 14th and 15th. And by December 16th, they're meeting about firing her, and they fire her on the 17th. Never heard of anyone getting fired so fast, particularly by a municipal employer.
I think that was the escalation of the conduct. Because what you have to remember is she reached out to the mayor's wife in October.
And
there was
nobody says anything.
There was no discipline taken against her.
No one even says like, hey, heads up, maybe don't do that.
And then she goes to the account clerk position, and all was quiet on the home front, so to speak, for a couple of
Until
months.
December 14th.
Until December.
And then she's fired on December 16th.
And
I
then
mean, that's
it is just
extraordinary.
one thing after
But
another.
over 2 days, like maybe she's having a bad, I guess it's not in the record, but well, what is your best response to both people say in their deposition, we use progressive discipline, we start with coaching, it escalates to warnings and so on. And here, the misconduct is on the 14th and the 15th, and by the 16th, they're talking about firing her, and they've done it on the 17th.
The progressive discipline policy that's articulated in the handbook,
Well, I don't think the
Is-
handbook is your
right.
problem, it's the deposition testimony.
Is there a policy in the, I didn't think there was, is there a progressive discipline policy in the handbook?
there is a progressive discipline
There is?
policy in the handbook, I believe.
I didn't see it either, but then the city manager and the city attorney
I think
both
there
said it was.
is.
Okay.
So this strikes me as like an important difference. I guess I'll look back, but it seems like it's a different story if you have a policy that says this is what we do as compared to a deposition where they say, this is how we operate, like this is our practice. If they're violating a policy, right, it would be odd to have a story where they're violating a policy in order to fire somebody for violating a policy. But if instead they're describing, as I took their deposition to be, not a formal policy, but, a practice that they typically engage in, that seems like a different line. And so if it's in the employee handbook, it seems really problematic for you.
And let me rephrase, I don't have the handbook policy in front of me. It says that certain things can lead to termination, and the list is inclusive but not exhaustive. And that's where it talks about insubordination. That is the testimony that Attorney Marsh was talking about with regard to the insubordination.
Because in any context we have, that like, even a progressive discipline policy, presumably there's something that you can do that would get you fired immediately.
Exactly. And the insubordination is one of the things in the city's handbook that can lead to immediate termination. That's articulated in the handbook, and that was articulated in the
It's
brief.
immediate? Does it say immediate?
I don't know if I don't know that it says immediate,
Okay.
but it says that it can lead to termination.
Well, of course, I mean,
And here,
Well, in this case, does the plaintiff assert there's a provision in there that you violated?
I'm sorry, Judge
Does the
Gregory.
plaintiff, assert there's a provision in writing that you violated?
I
mean,
am
see,
not.
that's the plaintiff would have to bring forth on that, wouldn't it?
No, there's,
You
in
don't have to,
looking
you
at
don't have to
the,
load your gun, put bullets in the gun for somebody else.
in-
I look for it, I don't see it, I'll just tell you, I don't see it,
Yeah.
but maybe I'm mistaken about this.
in preparing for this last night and reading the briefs again and the record, there is no argument by the plaintiff
Right.
that the city violated any provision of the employee handbook.
Right, but your colleague does argue, both people testified, normally, this is how we do it, and they didn't do that here, and we do have cases that say departing from a practice in how you usually discipline people can give rise to an inference that there's something else going on here.
It can give rise to an inference, Judge Harris, but when you look at all the evidence in the case, we believe that the evidence does not establish a pretext. When you look at the
Well, the evidence doesn't have to establish it yet, right? I mean, the question is, does this go to a jury or not?
Well, and I don't believe that there's any issue of triable fact
Okay.
that the plaintiff has established in the record that would get this to the jury question of whether there's a
I
pretext.
guess if I were going to try to make the other argument, like, as quickly as possible, it would be like, look, 7 years she's working for this city, no problems. She goes on leave. Immediately after she returns, she is told for the first time, actually, there's a whole host of workplace problems. We're putting you on an improvement plan. And then, according to her deposition, which I think we credit for now, they effectively force her out of her job. So that happens as soon as she gets back from leave. And then, a couple of months later, she is fired with lightning speed and with no effort to engage with her in the way that both the city manager and the city attorney attest is their normal practice. There's no effort to do any of that. And to this day, the city can't give a straight answer as to why she was fired. How does that not get you to a jury?
A couple of points on that, Judge Harris. With regard to the placing her on the performance improvement plan after she came back from leave, what happened factually was when she didn't make the Facebook or the social media post as requested by the city manager, she requested a meeting to outline her duties. So it wasn't that.
But she is told at that meeting, and I don't have it in front of me, but we have problems with your work. Like, you don't do stuff on time. There was another thing. And according to her, this is the first she's ever hearing about this.
And that's part of the argument that the plaintiff made in the underlying record, that there were no issues at all, and that's just not true. There weren't a lot of issues, I candidly admit, but she was written up or given a verbal warning, and obviously we know the only way you can document a verbal warning is to put something in writing. There were emails from January and February of 2021 with regard to not calling off work properly and some taking longer lunch breaks. I think there are also some other emails in the record, but I can't point you to those at this point in time. But so the argument that there was no issue at all is not true. So she is asked to make a post, and remember, this is her job. She's supposed to make posts. The evidence is not developed in the record that her job duties were heightened or there were somehow things that were added to her job during that meeting. She was told what the expectation of doing her job was by the city manager, that she was expected to make so many social media posts and do so many things, and her response was, I don't think I'm going to be able to fulfill these obligations. At that point, if the city had terminated her, I think the plaintiff would have a better argument that they terminated her because she just came back from leave. But the city didn't do that. The city gave her another opportunity because she couldn't do the job duties that were being asked of her, so she moved into another position. And then she was fine in that position until she started these things in December. So I think that the evidence developed in the record below does not. We would submit that there was not a prima facie case of retaliation in the first place. The district court assumed that and then moved to the other, the burden shifting analysis. at a minimum, we think the record is sufficient to establish that there was no pretextual reason, that Ms. Spatafor was terminated for the insolence and the insubordination, for violating the grievance policy, and for posting things on social media when she was not supposed to do so. And for those reasons, we believe that the summary judgment order should be affirmed.
Thank you, Ms. Durst.
Thank you.
Ms. Atkinson?
I'm sorry to ambush you, but I want to start with a factual question.
Please.
So when I look at your brief, you cite for the progressive discipline point, you cite to JA 275, which is part of the handbook. I read that and it doesn't say anything about being a progressive discipline. Where is it that I would find in the joint appendix? That's the site that you give me. Where would I find the progressive discipline, like quote unquote policy? I know you talk about it a lot, but the only site I see is JA 275. And hypothetically for me, except that doesn't say that there's a progressive discipline policy. Where else might I look to find it?
So two things. You're in the right place in that 275 to 280 detail the various levels of discipline that the city can use when disciplining an employee. This was raised with my colleague, and I acknowledge that there's nothing in this policy that says the city has to go from step 1 to step 2 to step 3, starting with a verbal reprimand, written reprimand, and moving up towards suspension and ultimately termination if that's appropriate. That's not mandatory under this policy. Yeah. But you clearly have laid out here these various levels of discipline, and the city manager and the attorney are testifying like this is how
So
we implement this policy.
City manager testified, so tell me where am I looking for that? Yeah.
May I get it?
Just ballpark, I don't need like a literal quote, but like, where in the JA? I just would love to like flip to it while I was like trying to figure it out.
Sorry, give me just a minute. I think he testifies that in his experience as city manager, when an employee
Like a word
commits
I can
misconduct,
search.
he's,
Anyway, that's okay.
Anyway.
I'll try to find it, but what we're really looking at is whatever his testimony is.
his testimony that in practice, the city, when they find it's appropriate, starts with the least restrictive or least severe means of disciplining an employee and works
When
up
it's
from there.
appropriate, I mean, that's what I'm trying to
Well,
get at, right?
and that's
Like,
what's difficult from the employee's perspective when the city comes back and says, we can do essentially whatever we want when it comes to employee discipline.
But it didn't say that in this case. In this case, in this case, you had a PIP, didn't you? Didn't it? Wouldn't that give some indication of their culture in a sense? Didn't she have a PIP?
She did.
Is that progressive discipline? Isn't that one of the primary, very stellar aspect of progressive discipline, isn't it? That's the best you can have. That in the sense that rather than hit you with a hammer, we're going to lay out a plan to improve you. Isn't that? I'm just asking you.
I don't think that the personal improvement plan in this case identified issues with employee misconduct or an employee.
No, I'm talking
kind of-
about you saying these inferences that they don't help people and that they just, but wouldn't that be evidence that they don't do that? They say, listen, let's work, let's try to help you, let's point where your deficiencies are, the weaknesses are, and let's have a plan for improvement. You can't have it both ways. You say, because you were fired, it means you're just, no, but you got to look at what happened along the way, right? And what they're saying is that there were problems, right? And her job was posting, right, Facebook stuff. So therefore, that was, she has a voice on Facebook, right? And so it's very helpful to distinguish when the voice is not the voice of the company, doesn't it?
She did. I mean, she wasn't the managing specialist at
Not
the
the
time
manager, but
posted
she
on- yeah.
posted, right? Didn't she, for the company?
She posted her concerns on
No,
Facebook.
no,
that-
I'm talking about
Oh,
politics.
back then, yes,
Yeah,
that was
yes.
part of her
Right,
job
okay,
before she was moved down to
Go
accounting.
ahead, go ahead.
So I'm almost out of time, Your Honors, just to reinforce the point, that the city issues this letter through its attorney to Ms. Spatafor, identifying the supposed reasons for her termination: insolence, insubordination, posting of internal documents. The evidence of record suggests that the city manager who is responsible for the termination decision can't precisely identify what that means. And we know from this court's precedents that changing reasons, nebulous reasons, are evidence of pretext.
Right, but we don't fault Falk for not having a vocabulary that includes a word that like is not commonly used.
Insolence, no, I don't fault him for that, Your Honor. But he could not tie what Ms. Spatafor had allegedly done.
Well, but
to
you
the-
asked him, like, what did she do this incident? He's like, I don't know what that word means, so I can't possibly answer that question, right? Like, I guess you just went to that. I'm like, you have lots of good argument. That seems like a bad one.
Right. I appreciate you pointing that out for me, Judge Richardson. But again, the city policy identifies what insubordination means. It means failure to follow an order. He couldn't identify how Ms. Spatafor failed to follow an order. The city goes from 0 to 100 in deciding to let her go while she's out with COVID. And while my colleague asked the court, like the district court, to draw inferences in the city's favor, it's not appropriate at the summary judgment stage. Ms. Spatafor has presented genuine issues of material fact on these claims. We ask the court to reverse the decision of the district court.
Thank you, counsel.
Thank you.
Thank you both. We'll come down and greet you, and then we'll proceed to our next case. No, you're good. Yeah. Counsel is still removing her things. And your colleague is coming up. All right. Mr. Robinson, you ready?
Good morning, may it please the court. My name is Philip Robinson, and I represent the out-of-state service member appellants who were subjected to Maryland judicial proceedings and transactions when Maryland lacked jurisdiction over them. There was no or little due process, and Maryland failed to comply with the mandatory statutory and protection required by all courts, including Maryland state courts. In sum, the appellants had no contacts with Maryland. They didn't live in Maryland. They didn't work in Maryland. They didn't have property in Maryland. They were, Mr. Riley, Mr. DeVenis, and Mrs. Rouse were stationed in Hawaii, North Carolina, and Texas, while in the Army, and their families were with them. Their spouses are also protected under the SCRA. Notwithstanding these facts, Maryland claimed to have jurisdiction when none existed. Under the SCRA, all Maryland courts are required, quote, in any civil action or proceeding," end quote, "before entering a judgment to require the presentation of an SCRA affidavit if the defendants are in military service, as the appellants were here."
Can I just stop you? I have some confusion about how all this works, and I want to let you get to the argument, but I want to make sure I understand what we've got. You just mentioned the civil action in the SCRA. I'm trying to figure out what was the civil action here. Is that the sort of what I'll call the sort of enrolling of the domestication, if you might, of the foreign judgment?
Thank you for the question, Your Honor. And the SCRA does cover civil actions and transactions. That's in the phrase. And here, what happened, just procedurally, is Mr. LeMay presented what appeared to be, but were not, valid judgments. They were not entitled to.
And I understand, I know you want to make arguments. I want to try to understand how it works first before you get to the,
Right,
I know they're not valid judgments, I know all of that. Help me understand how it works first, and then make your argument. So when he files it with the affidavit, that's the action.
He didn't file it with the affidavit, but the
No,
way.
he filed it with the affidavit required by the Maryland statute, not the
Right.
SCRA affidavit. There's an affidavit required under the Maryland domestication statute.
Correct.
Right? He files that affidavit, he files the judgment, and that's the action.
That's the action and proceeding. Yes, Your
And so
Honor.
then we go, and so that's done pursuant to the state statute, right? And then we go to the rule, which is 3-645, right? This is the writ, right? The writ of garnishment rule, right?
Yes, Your Honor.
And that ruling says that you can get a writ by filing, quote, "in the same action in which the judgment was entered."
Yes, Your
Are you
Honor.
tracking me? What, in that sentence in the rule, what is the action there?
In the action there could be the underlying case. If it was a case that started in state court, it could also be in this case.
I'm talking about in this case.
Once the foreign judgment is enrolled under the Foreign Judgment Act in Maryland, it becomes effectively a Maryland judgment and
Okay.
that action.
And so when I'm reading 3-645, and it says you can get a writ by filing in the same action in which the judgment was entered, the action is the one where the foreign judgment was filed, and the judgment was entered is the domestication of that judgment.
Correct, and it's assigned, when that foreign judgment is entered, it's assigned a case number, so it's all filed in
Yeah,
within the
so that's
same,
part of the action.
within the same case number.
And so, and I think you agree with all this, I'm just making sure that I understand it. And so the SCRA applies to that initial enrolling or domestication of the judgment. So when you show up with the affidavit and the foreign judgment, the SCRA requires what I'll call the military affidavit, separate from the domestication affidavit, to be filed at that time.
That's our position, Your Honor. That's then in place with the definition at section 3911-9.
All right, so now with that background, tell me why you have standing to sue the justices. Because the justices don't enact the statute for domestication. They enact the rule, but the rule is all downstream, right? And so it seems like you agree that the SCRA requires the affidavit to be filed under the statutory scheme. And so the rule, which is necessarily downstream, which is the writ of garnishment, operates in a world where the SCRA should have already been complied with, because it should have been done at the initial filing of the foreign judgment. So none of your problem is with the rule, it's with the statute. And so I don't see why we're suing the justices.
Your Honor, we're suing all of the officials that were named and the proposed ones to be named in their official capacities against the state. And there is no
The only
case.
people we've got here are the justices, right? Who do we have before us that's not the justices?
The governor, and we have, in our proposed second amended complaint, we have the administrative judge for Garrett County, which is Western Maryland, and Anne Arundel County, and the administrative clerk for Garrett County, and the
All right,
administrative clerk
let's
for...
start. We can break these apart, but start with the justices for me, right? That's the point of the rule being a problem. So how do you have traceability with respect to the justices? Maybe start there.
Well, there's two sets of claims that are on appeal that we've preserved. So one is declaratory judgment claim, where we're challenging the regime, and we outline not only the rule that you've pointed to, the garniship rule, but the other parts of the Maryland regime.
Which
that
are statutory.
Statutory and rule-based, Your Honor. And so we are seeking in this case a declaration that they don't comply in those instances with the SCRA, just as they did with our clients. There was no compliance with the SCRA. And so.
But why is that? So again, so your injury, maybe start with this in standing. I don't want to take all your time, but I want you to give you an opportunity to sort of address this, because otherwise this could be rather short. What is your injury? Article 3, what is your injury? Was the freezing of your assets, your client's assets?
The damages that are alleged and then before the court
No,
that's
not
in the record.
damages. I'm not asking about your damages. I'm asking about your Article 3 injury.
And they overlap with the injury. So the general that apply to each of the three families are the loss of the use of their money while their funds were garnished, and in one family's case, the funds were taken. They suffered emotional distress damage as a result of having a foreign jurisdiction assert jurisdiction over them when it lacked jurisdiction. It cannot, it effectively
what's the other
accepted
one?
a judgment, damage to their credit, and in this context, and it's detailed in the papers before the court and in the record, that they had to explain to their command structure why this Maryland court was
So
asserting
tell
a
me
judgment against them.
Tell me why those injuries trace back to actions taken by the justices. For traceability, why do they trace back to an action taken by the justice? What is the connection that you're alleging for Article 3 standing?
And I didn't finish the list, but I'd like to just, so it's clear, each of
You
my
can choose not
clients,
to answer the question, or you can choose to answer. Either one's good by me,
The
but what I'd love for you to do is tell me why it traces back.
the justices are named in their official capacities as the ones who enforce Maryland laws that are subject to this and Maryland rules. They're named there only in their official capacity, and typically, in an official capacity suit, the state is the right party. And we candidly, I admitted in our briefing, maybe, there's never been a case like this before that I know of. Nobody cited one to the court. And candidly, maybe the state was the proper party. We sought leave in the second amended complaint because we had a cascading series of defenses, not a defense based on Article 1 standing, which I'm happy to address and can be addressed at any time, and I'm attempting to do that in the best of my ability. The last damage the two damages and injury that occurred here was my clients incurred legal fees to defend those state court actions when Maryland had no jurisdiction, and they also asserted claims for nominal damages, which under the Uzabadn, I'm not going to pronounce it right, but Uzabadnam case, Justice Thomas wrote nominal damages are enough for Article 3 jurisdiction.
For the injury, not for traceability, right? So tell me why it is you think the justices, as you say, enforcement of Maryland laws. Can you put anything more on that other than just generally the Chief Justice rides around enforcing Maryland laws? Is there anything you can tell me that the justices have done or do that has caused any of the injury, is traced to any of the injuries that you have just identified?
Well, the justices have, and the governor has, and the local administrative judges and clerks have a duty to comply with all Maryland law, with the federal law. The justices, and we cite the In re matter out of Demlouy case, recently removed a judge from the bench who did not act in a manner which complied with the law. So they have ultimate, we're not saying they're individually, personally responsible.
I thought the district court said this, that your theory is that the justices should have promulgated rules that would have brought this system into compliance with the SCRA. Was that not your theory?
That is a theory upon which they could have mitigated the damages, they could have settled the case, but here, we're talking about
Why isn't
enforcement.
that sort of your answer to Judge Richardson, that the tracing, the traceability is that your whole theory, whether it works or not, but your theory of the case was the justices are to blame for this because they should have, but didn't, promulgate a rule of civil procedure for Maryland that would have put this whole system into compliance with the SCRA.
And ensure that the local
And they
judge.
could have done that, like,
That is one way, and that gets us to a problem of legislative immunity. Should they have promulgated a rule that complied? And so I think my response is they have a role and responsibility named in their official capacity to make sure that the Maryland courts enforce federal law, which is supreme law of the land, under the Maryland Constitution is recognized, and they waived any immunity. So that's our traceability there.
Yeah, but the thing, Judge Harris must have read my mind. I was saying the same thing. It's the promulgation of it is your theory, right? It's a legislative type aspect of it too, is it, right? Because they oversee in terms of promulgating it, right? They have committees and they get the final approval whether or not.
That's all true, Judge Gregory.
I think it's very important in your case, but you know your case better than I do. But when Judge, my good friend and colleague Judge Richardson asked that question about traceability, I think that's a big part of it, the promulgation aspect of the legislative and that thing. I guess we'll get into it maybe in dealing with it, because that's what the district court said. He said, I found no, there's a double negative. There was no legislative and no non-judicial action that caused that's involved here, and that's why, in terms of, that was a big part of the ruling, wasn't it?
That was a big part of the ruling below.
But isn't there a response to that? Well, what is your response to that?
Well, I think as to the declaratory judgment, I don't think there can be immunity for legislative, this is an omission case. The theory is they omitted under the Maryland scheme enforceability of the SCRA, which is supreme. And so, again, we only name them in their official capacities, but we've also identified those local judges and clerks. The state's position in response is no one, absolutely no one, although they admit that all state court officials have to enforce the supreme law of the land. They argue that neither even the local judges or local administrative clerks named in their official capacities, which is basically a suit against the state, have any issue. If Maryland, in this case, had required, and the local courts had required the presentation of that affidavit, and the affidavit showed that the service members were active duty, which they all were, and their spouses were entitled to the same protections, then before enrolling that judgment to become an effective Maryland judgment, they would have had to appoint counsel. And what we know what happened here.
Would it suffice, this is this omission scheme, if the Supreme Court had issued a rule that says members of the judiciary in Maryland must follow federal law? Would that have sufficed? There would be no omission then.
I don't
So
think that rule is actually needed, Judge Richardson, because it's in the state constitution already. It's in the supreme law of the land.
So then the question is, right, that's where I was going next. So what then was omitted, right? Does any judge not know that they're required to comply with federal constitutional law or federal statutory commands that govern them?
They're presumed to know the law, they're required under the judicial canons, and that's out of the Malloy case.
What was the Supreme Court, in your view, then required to do? Like, what did they fail to promulgate, or what did they omit, given that every judge is presumed to know that they cannot ignore the federal Constitution or federal statutory commands that govern their conduct? What was omitted?
There's an omission in the process to ensuring that this enrollment of a foreign judgment and thereafter the immediate enforcement of the foreign judgment through the garnishments comply with the SCRA. I think it's footnote 12 of our opening brief. The Supreme Court did acknowledge and promulgate during this case a rule that recognized that SCRA affidavits at some moments in time becomes stale, and there needs to be a new one filed. Different proceeding that's not before this court, but the staleness was there. And if I may indulge and go into my rebuttal time in a minute. So
I won't take your rebuttal time. Go ahead.
these are all really important questions, and this is a case of first impression. The Supreme Court justices were named in their official capacities. If the court is going to take an Article I view that we don't have jurisdiction, then the proper remedy would be, I think, dismissal without prejudice as to the justices. And there shouldn't, that gets us back to, we sought leave below to cure some of these perceived arguments. The state didn't raise an Article I argument, but.
You're talking about Article 3, right?
I'm sorry, Article 3.
I just want to make sure I'm not,
No,
it's a
no,
different
I-
argument.
you know,
You're fine. I'm totally good.
Judge Richardson, you know I have Article 1 in my head because Article 1 gives vest all military powers
Yeah, I got
to
it.
Congress. And the state here is through its process of omission, is exercising authority to ignore that and to interfere with that federal policy. That's our core crux SCRA claim. And by claiming, oh, we don't have to do anything, or omitting to ensure that there's proper enforcement by the state courts, which are all supervised by the state Supreme Court justices, but be that as it may, if they're dismissed under Article 3 theory, that would be without prejudice, and we'd be back to where we were at below, which was adding in the administrative judge and the administrative clerk for each of the local courts, which gets us to the same issues that are before the court, we think, in our appeal here. By and large, this case rises and falls under Torres. And this court, in the Jackson Creek case recently, the 11th Circuit Williams case, recognized, and Torres and those other two cases recognized that the rights here, the protections here are categorical. The Maryland, whether it's through its state court system, doesn't have the right to ignore the rights and protections that Congress made mandatory in 2003. But that's what happened here. Now, whether we have named the right party, whether we have Article 3 standing against the justices or the governor or the local, it seems the argument from Maryland is none of them are responsible. No one. And that can't be how this traceability. I'm not sure who else we can name other than those individuals.
You did have an action against Mr. LeMay, right? Am I remembering it right? I mean, it seems like the obvious person you would sue is the person who registered these judgments.
And we did sue
Okay.
Mr. LeMay. And Mr. LeMay is not responsible to appoint counsel. The state is. That's what the law says. Mr. LeMay was responsible, the state was supposed to require Mr. LeMay to present that SCRA affidavit that's fundamental and basic to almost every transaction that I've ever been involved with. And the state didn't require him to do that. And he testified, and that's in the record in the Anne Arundel County proceeding, why, and the question was essentially, why did you come to Maryland? He said, because Texas wouldn't let me enforce this judgment. Now, just to be clear, just to sum up on the facts, there's not really a lot of factual issues in this case, but it's a little strange when I talk to other people about it. This case involves two judgments that Mr. LeMay presented. On a piece of paper, they said judgment. They were not. They had been vacated. So they weren't valid judgments. They were certified by a state court. He got a piece of paper that said judgment on it. It was certified record from a state court, but that didn't make it a valid judgment because the subsequent order had vacated it. So it's in essence is a default situation. The third one with Mr. and Mrs. Rouse had been presented from a jurisdiction in Nevada where they had no jurisdiction over them. They lived in Hawaii. So there's sort of a problem there, and that one's essentially, I think, voidable under the law. But none of the three were enforceable. Had an attorney been appointed as required by the SCRA, that attorney would have seen what I see. How does Maryland even have jurisdiction over these people, and could have addressed it before the cascading of errors that occurred? And Mr. LeMay was permitted by the Maryland court to get a subpoena for confidential service member financial records from a foreign corporation. He was permitted by the Maryland state courts to get multiple garnishments. He was permitted to seize monies and execute on those garnishments. And all of that could have been stopped and prevented, but for the omission of the enforcement of the SCRA by the Maryland courts. Unless there's any other questions, I'll rest for whatever time I don't have for rebuttal.
Oh, you have rebuttal time.
Thank you.
Mr. Robinson, thank you. Mr. Cox?
Good morning. May it please the court. Kevin Cox on behalf of Appalese, the Governor of Maryland, and the Chief Justice and Justices of the Supreme Court of Maryland. This case presents a challenge to the structure and operation of not only Maryland's judicial system, but all the judicial systems of the 50 states and the federal judicial system, based on alleged violations of the Service Members Civil Relief Act, otherwise known as the SCRA. The district court correctly dismissed the claims against the governor, granted summary judgment to the justices, and denied leave to amend a second time because amendment would be futile. We respectfully urge this court to affirm. The primary issue before this court is whether the governor and the justices can be held liable under the SCRA for alleged violations of the SCRA occurring in the state district court. The federal district court correctly held they could not be liable. That is, the court correctly held that the justices have legislative immunity for the acts alleged, which is the only alleged violation of the SCRA, and which was their failure to enforce the act through enactment of the Maryland rules incorporating the affidavit and assignment of counsel provisions with respect to the collection of judgments in Maryland, as opposed to obtaining default judgments in Maryland.
Wait, can you just help me? I have a hard time. I understand the district court below made an effort to distinguish Graham. Can you help me sort of understand why, when you sue an official capacity for damages, which is what they've done here, that the state only gets sovereign immunity, right? Not the individual immunities that would otherwise apply? I get this question doesn't come up a lot because sovereign immunity generally applies, but we obviously, as your colleague referenced, we got an Article I different issue here, and so we don't have sovereign immunity, but I have a impossible time so far understanding how an official capacity suit for damages we apply individual immunities.
I think the answer is directly in Consumers Union, Your Honor.
All right, so help me understand why that is, because Consumers Union's not a damages case, right? This is the Ex parte Young idea that you can enjoin the state officials from taking action, and it's a fiction. We all sort of recognize it's a fiction at a certain level, but we can do that, and that's why Graham doesn't matter there, because that's a suit for injunctive relief, not for damages.
Well, mostly, Your Honor. I think the circuits and several circuits have examined Consumers Union almost directly on that issue, because it's 1988, Section 1988, and attorney's fees were at issue in Consumer Union. And the idea...
Yeah, but that's a different line, right? So they get to attorney's fees, and what the Supreme Court says in the attorney's fees section is that they shouldn't have awarded attorney's fees because you didn't prevail, right? This is just like an attorney's fees line. You didn't prevail on the argument that the district court based the attorney's fees award on. That is the promulgation of rules, right? Not that it wasn't permissible, right? It just says that you didn't prevail there. And there might well have been attorney's fees in some other context, right? So I guess I have a hard time understanding the attorney's fees argument too.
Well, I think it's the idea of when their personal immunities, if it's an official capacity claim, it's going to be a claim against the state. Essentially, you're going after the purse of the state. And in Consumers Union, it was very clear that the Supreme Court cut off a claim against the Supreme Court of Virginia for a claim of attorney's fees, which would essentially say you can't get public money for something that the underlying official would have legislative.
Does it turn on that for you? So in other words, if I read Consumers Union to say instead, you don't get attorney's fees because you failed to meet the statutory requirement, that it would be an abuse of discretion Not that there's a, structural problem, but it'd just be an abuse of discretion to award attorney's fees to the justices and not the bar for something that the justices were not found to be responsible for. Right? I mean, that's just like an attorney's fees case. That doesn't go to Graham's point at all, it doesn't seem like to me.
Well, not so much whether it's an abuse of discretion. I think it's an overarching principle, and it's something
But the Supreme Court says that it's an abuse of discretion, right? It doesn't say that there's some other issue. What it says is there's an abuse of discretion to have awarded fees.
I think what the Supreme Court was saying there, in the circuits that have looked at the official capacity, applying legislative immunity to official capacity claims, implicit in those decisions, and these cases are identified in the district court opinion, they're identified in the briefing. I think it's the first, the second, the third, the 11th, and even the 6th and the 7th circuits have applied these official capacity the personal immunity of legislative immunity to official capacity claims against the state, and I think implicit in that, and the district court.
For damages, is your argument.
Our argument absolutely is, Your Honor, is that it would
But
apply.
those cases don't do that.
Those cases do not, you have to parse through the language to determine that they're taking the principles of consumers' union. And they actually say, I think it's the Scott case, Your Honor, which is identified in the district court opinion.
It does say it at the end. It's inconsistent with everything else Scott says, but at the end, it has a dicta line that supports you. I agree with that.
You are absolutely correct, Your Honor. And you're going to be hard-pressed. And I think it's just intuitive to our system, and that's what the district court essentially got to. The district court couldn't identify case law saying that the damages portion for the immunity would then flow to the state explicitly. I think the district court found it to be implicit in consumers' union. In these cases, used the
Can I just,
1988.
back up a hair. I mean, it is a little bit odd, because in lots of other, we think about qualified immunity as one of these personal immunities, right? But we all know that if you sue the Monell, if you sue the actual entity, right? The entity the municipal entity doesn't get the benefit of that personal immunity. We instead analyze that under Monell, and there's a whole set of questions, but they don't get the personal immunity that the officer is entitled to. This seems like the same basic structure. It seems like to me that this is like the move that we're making is that where you're seeking those damages, right, which is Monell, like you rise and fall based on Monell's requirements, but you don't get qualified immunity. When we say that over and over again, that's a personal immunity. It only applies when you're seeking damages against the officer, not the municipality. Isn't that the same context that we've got?
Close, Your Honor, except that you hit the nail on the head by using the word municipalities. None of those cases, and I know I'm familiar with the cases you're referring to, absolutely, Your Honor, but I'm not aware of any against the state.
Yeah, that's totally right, because the state has sovereign immunity, and the municipality doesn't have sovereign immunity. You know who doesn't have sovereign immunity here? You, right? You don't get sovereign immunity. You are like a municipality because you lack sovereign immunity under the plan of states, right? Normally, you're right. You would have sovereign immunity, and that's why this doesn't come up. But you are like a municipality here. You stand with no sovereign immunity.
You agree with that, don't you? You have to concede that.
I don't, Your Honor.
You don't?
I don't concede that we do not have sovereign immunity here, and I know what you're referring to. You're referring to the Torres opinion, and we did not brief that. We briefed it below. That argument was briefed below. We did not bring that. We did not brief that before this court of whether sovereign immunity was waived for SCRA claims.
For our purposes, that means you've conceded it.
Yeah.
For our purposes. Yeah,
Fair.
I understand. You could go to some other case and argue it, but not here.
That is exactly what I meant by that,
Okay.
Your Honor.
Right.
So what is the other distinction in the Monell qualified immunity context? Because you're like a municipality, you don't have sovereign immunity. Tell me why you should get the just like conceptually, I bracket for a minute what I think is your argument of consumers union. like, why conceptually would you get the individual immunities of, like, a police officer or a justice?
Absolutely, Your Honor, and the district court struggled with this. For example, there's some quotes from the language I'd identify for page 15, for example, or I'm sorry, head note 15. But the court starts by saying, to bar the invocation of individual immunities, then would be subject the state to suit over conduct for which its officers would be individually immune. The court is unaware of a prior instance in which a private party was permitted to recover damages from the state over an affirmatively harmful law or judgment, much less an insufficiently protective one. So
But
there's,
that's Monell, right? So that, the example that the district court judge should have said is, where that happens is the numerous cases we have where officers are entitled to qualified immunity, and the municipality is still responsible under Monell because they don't get the individual immunity.
and if that's the case, then you have every legislator and every judge, and let's focus on judges here, justices, for example, every time they would rule in a case, they would have to worry about, can the state be sued for damages for my ruling in this case? Because under the appellant's theory here,
They wouldn't, because they wouldn't have adverseness there, and so I don't think it'd be a problem there, but maybe, but like, that's not my job, right? My job is to sort of say, like, do you get the individual immunity as the state?
Well, and-
Stop, sorry, I'm taking up too much of your time.
Oh, no, absolutely. I'm happy to answer any and all questions, Your Honor. And you mentioned, I think, adversity, and I'd like to talk about, use the term traceability earlier. And I think that's really what this case falls back on. And Judge Harris and Judge Gregory, you were asking questions about this to appellant's counsel. What is the claim here? That still, I mean, let's just put aside, Your Honor, Judge Richardson, if we put aside the legislative immunity discussion, appellants have still not identified any act that the justices took here, or the governor took or could have taken, other than just promulgating rules or enacting statutes. And the idea, take their argument to its most logical conclusion, no statute or rule had to be enacted. The argument is the SCRA is the law of the land, it controls here. So no statute, no rule needed to even be enacted. And in reality, their claim then would be, and this was as the district court finally pointed out in its second opinion, it seems like their claim really is against the individual judges ruling in their case or their clerks. And I think that is what they're trying to stay away from due to obvious judicial immunity.
Well, tell me, do you agree that Maryland stands in the shoes of Nevada and Texas in terms of it can't be any greater power than they had? In other words, full faith and credit is the origin of that, right? You come to a state and they enforce foreign judgments. But whatever power that Nevada had in Texas, Maryland can't have greater power over that judgment, can you? You agree with that?
I think full faith and credit would be equal power there.
Equal power, right? And part of that, it has to subordinate itself to Article 1 in terms of protection of service members. And that is, you're supposed to get an affidavit to say that whether or not a member, in terms of the defendant in this collection case or whatever recovery, is not a member, service member, and if they are, then appoint them counsel. And you agree that Nevada should have and was required to do that. You agree with that?
Nevada was required under the
Right.
SCR because that was the default
Right.
judgment stage.
Right,
Your Honor.
and then you took full faith and credit of that, then how do you absolve yourself of that responsibility? In other words, it's like maybe no good deed, goes unpunished in the sense that, aren't you also required to make sure those assertions, because otherwise you could frustrate Congress' power. This was consistent with the original interpretation of the Constitution itself. When it comes to Article 1, that's why you don't have sovereign immunity. And you couldn't just give this to somebody else and say, oh, they have qualified immunity as judges. They can do what they want to do, because that's what I think goes down to Judge Richardson's question. How are you now trying to assert individual immunities to get around what you don't have sovereign immunity yourself for. Because that's what you basically say. You should have promulgated that. You take these foreign judgments, you have to do exactly what it says. Get an affidavit. Was there an affidavit? That should have been in the record. It should have been attached to it. And if it's not there, why are you going to take these service people's, their funds and their families being frustrated? And that's what Congress said. That's what the Supreme Court said. It has to be so that, well, that's what Congress said. These men and women are fighting or on the reserve to protect our country, and they should not be worried about these things and domestic judgments on their families and suffering. That was important. That's very important. So Maryland, how did they just get away and say, well, it's not our fault, we'll just give a writ of garnishment, but we don't have to do those things that protect service members?
Your Honor, I have several answers to I think your
Start with
question.
not promulgating the record, I mean, because I'm very familiar with Students Union in that case, but it starts with not promulgating requirements that you do that.
And sorry, I just want to make sure you're asking me to explain why we didn't have to promulgate such rules?
No. Why you're not responsible? Why is that not? You can't use legislative and judicial immunity because they're not sued in their individual capacities, their official capacity. You can't use that to shield it, can you? The responsibility that the state can't even shield themselves. So how can someone under the state acting on their behalf shield them from it?
Well, let me start, I guess, with the initial premise with your question is that your premise is that the SCRA would apply to the collection proceedings in another state, in which case the SCRA would control, if that's what you're saying.
That's
there'd be
right.
no need for rules under your premise.
There would be need for rules, because you had the rules, they would know that. All of the lower courts below the Supreme Court would know that. The courts, just like our federal courts, we have the judicial conference, and they promulgate rules and things like that involves our operations as well.
Well, let me start by addressing your premise. Is our argument, as the court's well aware from our briefing, is that the district court did not agree with that, so it's in the alternative, is that the SCRA does not, the requirements for an affidavit and appointment of counsel do not apply in the collection phase of actions. And Judge Richardson was asking earlier, and this is part of the briefing, about whether those requirements apply to civil actions, proceedings, judgments. All that happens when a judgment's enrolled into another state, and this goes to your question too, Judge Gregory, is that it's not on the clerk's ministerial duties to look up the case in the originating state. It's what comes with that is a triple seal document, an affidavit affirming that this is a true judgment. And what you have here is a case.
Judge Gregory's question made me just wonder. The full faith and credit requires Maryland to take the judgment from Nevada. Mm-hmm. And we all, I think, agree that in Nevada, the court should have complied with the SCRA. Why wouldn't Maryland, you haven't made this argument, but why wouldn't Maryland be entitled to rely on that? So part of taking the full faith and credit of another state is the belief that they complied with due process, for example, in getting that judgment, that they complied with, basic notions of, judicial engagement, and it seems like to me that they complied with, other federal laws.
And that's
Because they're standing in the stead of Nevada, and I guess, I'm not sure why that matters, but it seems a little odd.
That's
right?
kind of our argument, Your Honor, but it's really, our argument is in response to appellant's argument that then the SCRA must apply again to the collection phase. And this case is a case of bad facts, us not wanting bad facts to make bad law. And that's what happened here with the creditor, who's a bad actor, George LeMay, where he received these judgments and then enrolled them in Maryland. There was no reason for Maryland or any of the other 49 states to question these judgments when they came in. They're entitled to full faith and credit, and that just means that entitles enforcement in Maryland under the Maryland rules on that. Our position is that the SCRA's affidavit and appointment of counsel requirements do not apply to the collection phase of that. And if you think about that, that makes sense. If this was still in the same action, if this was in Nevada, if this was in Texas, why would it make sense after the judgment was obtained, the very next day or that day, if the attorneys went to obtain, the creditor's attorneys went to obtain writs of garnishment, why would they then have to then get a new affidavit and appoint new counsel? That would not make any sense. That's why there's a separate provision of the SCRA for collection of judgments, which is
Can I-
3934.
Can I just, I tracked that argument with some care, and I didn't see you responding to the district court's reasoning on this point, because you make a really good point about these two separate provisions, and 3934, that's one that covers the enforcement or execution of judgments and garnishments, and breaks out garnishments separately from judgment. But the district court says, no, there must be an affidavit requirement because it allows for sua sponte dismissal because there's a service person involved. But unless there's an affidavit requirement, how would the court sua sponte ever know to do that? Do you have a response to that?
Yes, and may I request just time to answer, Your Honor? I see my time.
Yes, you may, yes.
Thank you, Your Honor. You're absolutely right. The district court identified kind of the loophole here that is created by this situation. Again, this just falls back to, you don't want bad facts making...
Well, it's not so much a loophole, right? You're trying to construe a statute, and it just seems like the drafters of this statute must have assumed the affidavit requirement in 3931 would also apply to 3934, because otherwise, like half of that provision, the sua sponte vacature, I think it is, provision can't do any work. Like it just becomes superfluous.
I think in reality, this argument in the district court kind of addressed this as well, because no one cited true authority on this, Your Honor, is this is just a pure, plain reading statutory interpretation of the statutes. And in response to your question, our typically, in our view, is that because this applies to default judgments, these cases, the SCRA, when Congress was writing the SCRA, they had the default judgment in their mind, sort of to Judge Gregory's questions earlier. They're not thinking ahead to enrollment years later, enrolling foreign judgments, collections years later. They're thinking about the normal process. And you have to sit down and really take a step and think about how typically debtor-creditor cases work. Normally, you have a debt, you sue on it if it's not paid, you get the judgment, and you start to collect on it right away. So the court would have that information because theoretically, most would be in the same jurisdiction in that same case. And that's why the statute is written the way it is. Now, that's our argument. Can I provide you any definitive case law on that?
That's perfectly
Absolutely.
good answer, thank you.
But this is, it's an interesting question, I suppose. Obviously, our court, we have to opine and come to a decision in this case. But, ultimately, it's one, I don't know, maybe the Supreme Court will have to decide one day in the sense that, because think about, you talk about bad facts, but if that's the law, you could easily just get against service people because they're out of the country many times. They're employed in the service of our country. Their families are here and sometimes other places. But you get a judgment and then you didn't do the affidavit, and then you can just take it to another state and they don't have to do anything. They just go ahead and just freeze your assets, take them and everything. Say, well, we just full faith and credit the judgment. I mean, it would encourage it. It becomes a roadmap for doing an opinion like that, wouldn't it, right? Because that's what you're saying. We're Maryland, we just go ahead, we just get the guns. We don't care who it is. We got a judgment.
Well,
It was a judgment that was void. This is the worst one. This one is like nuclear, because not only was it didn't do the right thing to get it, but Nevada and Texas had corrected their error and Maryland went along and just did it. And you said now it's nobody's responsibility.
You're exactly right, Judge Gregory. This is a bad actor, and no other state does it the way appellants would like it, the way you described it. All the research, the district court, the appellants, the appellees, no one's found another state that interprets the SCRA, even Washington, the Sprinkle case, which is identified and briefed heavily in the briefs, Washington didn't even go back, that I'm aware of, go back and update its rules to make sure that for collection proceedings or foreign judgments, that then the SCRA is complied with. So no, even the federal courts do not do it this way. That goes to our statutory interpretation argument, which is that it's not meant to apply this way. But let's just say it is, Your Honor. There's a built-in safety net. You can sue the bad actors, and that's what they did here. And they received over 6 times more than what the judgments were obtained against them. That is their remedy, and should be their sole remedy here.
Can I ask you just one more question about your statutory construction argument?
Absolutely.
Do you have a view on whether, I mean, we have case law saying we do a liberal construction of this statute, which is similar to the pro-veteran canon that the Supreme Court applies in cases like this. Do you have a view about how that applies here?
Sorry, I just want to make sure I understand the question, Your Honor. If you have,
If the statute's at all ambiguous, we're supposed to err in favor of the service person, take a liberal construction of the SCRA. How does that factor in?
our argument is the statute, the way we read it, is clear.
Okay.
All right, anything else? Judge Harris? Thank you, counsel.
Thank you, Your Honor.
Mr. Robinson, you have some time reserved.
Let me make clear for the record that I and my clients are not comfortable naming any judge in this case, but my clients and I have the firm conviction that the mandatory requirements in the SCRA need to be complied with.
Can I ask you to sort of address your colleague's statutory construction argument? Because I do find this very difficult. The garnishment writ has to be a judgment within the meaning of 3931 for your reading to be right. But then 3934 clearly breaks out judgments and garnishments as two separate things. So how do I read these two provisions together so that a judgment includes a garnishment if, you know, in a close to neighboring provision, Congress seems to think they're two different things?
But Congress has a statutory definition, so it starts and ends at the statutory definition.
No, it doesn't, because I'm telling you, why doesn't the fact that 3934 refers separately to judgments and garnishments, why isn't that very good evidence that I need to read that statutory definition of judgment to exclude garnishment? Whatever else it does, it obviously can't include garnishment, or that word becomes completely superfluous over in section 3934.
Judge Harris, that's an excellent question. So this was part of my introduction that I didn't get through when I got sidetracked, but I'm not going to leave the definition, because the definition doesn't just say any judgment, any decree, any order, or ruling. It also says final or temporary.
Okay, so you just think the word garnishment in 3934 is
I
completely
want to
superfluous.
apply that now to the 4 different types of judgments that are here. The registration, we think, qualifies under that definition. The issuance, the next thing is Mr. LeMay requests a writ, and it's issued by the local court. We think that fits squarely within the definition. Then there's a judgment on the garnishment. So Mr. and Mrs. DeVenus's case, there was one of the garnishees held monies that they had for them, and there was a judgment of garnishment. So that's like a third different variation here. And then in Mr. and Mrs. Riley's situation, there was a subpoena issued. So I think there's sort of a distinction if you look at it that way. And of course, we're just applying the definition, and Your Honor, I get that you have some uncomfortableness with one of those 4, but it can't apply to all of those 4, that uncomfortableness. And we think if you're reading it liberally, which is the Supreme Court said back to the 40s that this statute and its predecessor should be read liberally, we think it construes and it fits squarely here. At each of those steps, had they asked for the SCRA affidavit and my clients came back that they were active duty, the writs wouldn't have issued, the garnishment judgment wouldn't have issued, the subpoena wouldn't have issued, because a lawyer would have been appointed, and a lawyer just like me would have looked at this and said, how does Maryland have jurisdiction over these non-resident service members? And I could have raised the objections before any of those occurrences. those judgments or garnishments occurred. And we think under the plan and convention waiver that the Supreme Court articulated in Torres, which we raised in our opening brief, and the state has consistently in this case not addressed or sought to avoid or say that it's silent, controls. Here we have individual defendants, whether they're properly named or not, and we sought leave to name the state, we sought leave to add the local judges and administrative clerks. They can't assert their immunity defenses, and otherwise that would only interfere under Torres with the Article I powers that Congress has in the Navy Army clauses. So we'd ask the court to reverse the judgments below, and we think the record's pretty clear as to liability. Since the state didn't follow the law, our clients are entitled to a judgment of liability, and we sought that below, and we've sought that in our briefing here. And we appreciate the court's consideration of these, they're candidly complex questions that have never been before any other court. This has never occurred anywhere else. No other state has opened its courthouse doors to allow this to happen. Shouldn't happen again. Thank you.
Thank you, Mr. Robinson, and thank you, Mr. Cox. I will ask the clerk to adjourn the court for today until tomorrow morning, and then we'll come down and greet counsel.
This honorable court stands adjourned until tomorrow morning at 8:30. God save the United States and this honorable court.